My name is Richard August, and I'll be your host. Our guest is Frank Soccoccio, an attorney with the firm of Comerford and Soccoccio in Johnston. Mr. Soccoccio filed a lawsuit in federal court on behalf of two clients, Michael O'Neill, Vice President of the Second Amendment Coalition, and Nicholas Grasso, former President of the Federated Sportsmen's Association. The plaintiffs sued Attorney General Peter Nerona and State Police Colonel James Manny over a recent law that bans the possession and attempt to use an electronic stun gun, sometimes known as a taser, by civilians. Violators face a $1,000 fine and up to a year in jail. Now, that would make it a misdemeanor. The suit asked the court to declare the law unconstitutional and prohibit its enforcement. Mr. Soccoccio, would you explain the basis of this lawsuit to our audience?
Yes. The United States Supreme Court in 2016 actually heard a case called Jamie Catano versus Commonwealth of Massachusetts, in which an individual was actually prosecuted for the simple possession of a stun gun in Massachusetts. Massachusetts has an absolute prohibition against the possession of any stun gun. Rhode Island has a similar provision. So the basis for the suit was Michael O'Neill and Nick Grasso. They are licensed by the state of Rhode Island to carry a firearm, but yet they can't carry and can't possess a non-lethal form of protection known as a stun gun. We actually filed in federal court to ask the federal court to apply the same ruling that they did in Jamie Catano versus the Commonwealth of Massachusetts to the Rhode Island law, declare it unconstitutional.
So that is actually a United States Supreme Court ruling, the one that
United States Supreme Court ruling, correct.
Okay, so you're asking the U.S. District Court to follow that Supreme Court ruling with respect to the Rhode Island law.
That is correct.
Now, the argument in favor of the ban that was raised by Colonel Manny and also Providence Public Safety Commissioner Stephen Parry, a former state police colonel, is that such devices may be used against law enforcement personnel. How do you respond to that criticism?
There are other weapons that could be used against law enforcement personnel, but just because something can be used against a police officer doesn't mean that a private citizen should not have the right to carry it in their own defense against not a police officer, but against an individual trying to do them harm.
Now, law enforcement officers observe something which is called the force continuum, which goes from the least lethal method to the most lethal, in other words, the use of deadly force involving a firearm. So on that continuum, it's supposed to be a gradual escalation in response to a threat. Is that correct?
I'm unsure of that. I don't know if the police...
Because the point you're making about tasers or stun guns is they are a non-lethal form, so it'd be basically a defensive weapon.
Correct.
Okay. Now, when this bill was being debated, Attorney General Nerona's office did recommend to the lawmakers that the law should allow persons who could pass a background check to possess these devices. Do you have any idea why lawmakers did not follow his suggestion, and why then does the lawsuit name him as a defendant?
I'm sorry, could you state it again, please?
The testimony when that law was being, or bill was being debated, was that the Attorney General's position or suggestion was that if a person could pass a background check, that he or she could be allowed to possess a stun gun, but that did not make it into the law. I'm asking, do you have any idea why the legislation did not reflect that?
There were a couple of versions of the bill. The bill that I wrote initially, I went through the Senate, had a lot of safety provisions in it. In the event somebody wanted to carry a handheld device, they simply just had to be a law-abiding citizen. They could own one. If they wanted to carry the device which shot the dots out, then they would have to do the requisite training. They would have to pass a background check. They would have to apply and receive something similar to a CCW license on that. So to worry about people shooting other people with these devices that shoots the dots out, we'd want to have some kind of training on that. We also wanted to have provisions in there so if someone is a violent felon, they can't have them. Those provisions were all in the Senate bill. When it went over to the House, a lot of those provisions were taken out. I don't know why. A lot of the safeguards that other states had put in, which I put into the bill, were removed, and I don't know why. The reason why the bill failed is because Sid Weidel wanted to put an additional 10-year provision on that, so in the event somebody used it or tried to attempt to use it on a police officer, they'd get an additional 10-year sentence on any underlying crime that was being charged, and all of the support went away as soon as that provision was put in place, because nobody wanted to have a 10-year provision added on to the stun gun.
Mr. Wardell is the executive director of the Chiefs of Police Association in Rhode Island, correct?
That is correct.
So an assault on a police officer is already a felony.
Correct.
So his idea was that you would add 10 years to whatever
Underlying offense.
underlying offense. So if the person did assault a police officer with a stun gun, in addition to the penalty for that, 10 years would be added.
Correct.
Interesting. Now, as you said, both of your clients do possess concealed carry permits, so they can carry a gun.
Correct.
Legally. And it's unclear why they should be denied the ability to use a stun gun. And as you said, these electric devices are of two types, I believe. One is a handheld device that you would have to be in close contact with.
Have to touch the person.
Touch a person. The other is a device that you said shoots out
Two dots.
darts. So a not negative and positive pole that would be able to be used at a distance, at least a distance of the wires that
Correct.
connect it. And so there is really two different things. One would be a more, let's say, a more aggressive device than the other. One that shoots out the darts is a more aggressive device.
Correct.
So your bill would have included some provisions, safeguard provisions for those devices that actually project the darts?
Correct.
Okay. Now, no ruling has come down on this case that you filed, has it?
No, the Attorney General has already had 20 days to answer. They filed for one extension for 30 days. Now they want another extension to file 30 days. They haven't even answered the complaint yet.
Okay. There's really you're not aware of any reason why they're dragging their feet on this?
No, and I specifically asked, the United States Supreme Court has already declared this type of law unconstitutional. What is going to be your response to this? And I got no answer other than we need additional time.
But but in response to the complaint, as a defendant, he can respond.
He can if he responds.
Okay. And Colonel Manny has not, he's another co-defendant, correct?
Correct. Represented by the Attorney General's office.
Oh, okay. So, all right. So they're both, I was going to ask you if Colonel Manny had a separate legal counsel. Okay. Now, the Providence Journal describes you as the president of the Second Amendment Coalition and its chief lobbyist. Is that accurate?
That is accurate.
Okay. Now, the anti-gun lobby, as I call them in the state, paints the National Rifle Association as the great Satan of the Second Amendment community, claiming it buys the votes of lawmakers, and that's how they're able to withstand or hold off any what they call common sense gun control measures. The Second Amendment Coalition in Rhode Island is the NRA's official correspondent here, correct?
We are the official NRA state association, correct.
In other words, your organization employs a lobbyist on Smith Hill, who I understand is a former House Speaker, but my question is, how much money does the Second Amendment Coalition get annually from the National Rifle Association?
Zero.
You get no funding from the National Rifle Association?
Zero.
Now, the groups in favor of more gun control legislation, such as the Moms Demand Action, which is a subsidiary of Michael Bloomberg's Every Town for Gun Safety, and the Rhode Island Coalition Against Gun Violence, often make this claim. Do they receive any money from outside sources?
I'm not sure how their funding is, but I believe they are getting funding from outside sources, but I can't confirm that.
Would seem if the Moms Demand Action is a subsidiary of Michael Bloomberg's organization, he's the 7th or 8th richest man in the world. I suspect to get some money from him.
Okay.
The Coalition Against Domestic Violence in Rhode Island was one of the prime movers against the domestic violence bill that was enacted a couple of years ago, and then the so-called red flag legislation that also came along last year, I believe. They get more than $500,000 a year from a combined grant from the legislative side and the judicial side. Do you have any idea where do they spend that money? Do they use that for lobbying efforts?
I don't know where they spend that money, but they also get additional funds. Every person that is charged with a domestic violence crime has to pay an additional fee in addition to court costs, which go directly to them to help with whatever administration they have. So every person that's charged pays an additional fee.
Well, that's pretty interesting. Now, we recently had a shooting at an assisted living facility in Westerly by a man who 17 years earlier had been deemed to be homicidal and suicidal. Was well publicized. I'm sure you're familiar with it. Attorney General Nerona and others are calling for a tightening of background checks and the inclusion of persons with a history of mental illness in the FBI database used for the background checks. House Speaker Nicholas Mattiello and Senate President Dominic Ruggiero, generally regarded as gun-friendly, indicated they are in favor of this legislation. And you are quoted in the Providence Journal as saying that you have no problem in principle with this idea. Can you explain your position on this idea?
In theory, it sounds good. The concern we have is if it's going to create a gun registry and what information is going to be placed on that. My understanding is that Gina Raimondo wants the Rhode Island Department of Environmental Management to also start to create a list on people that are going to be applying for blue cards. That's going to be a problem. That's one of the things that Peter Nerona has stated on that. The concern that we have is they want to modify the section of law for the reporting for when somebody does purchase a firearm, where the information goes. Currently, it's supposed to go from the gun dealer directly to either the state police or to the police chief in the town where the business is located. That police chief should be sending the information or at least communicating with the chief in the town in which the buyer actually resides. And currently, I don't believe that was done in this particular case. There could be a clarification in the law which allows for that, and that shouldn't be a problem. But to go any further than that, I have reservations about what additional reporting and what additional information would be shared.
So as you said, the governor is going to propose or has directed Department of Environmental Management to begin to create a gun registry of buyers?
Okay. What happens is if you want to purchase a pistol in Rhode Island, you have to pass the blue card test. That is given out by DEM, also by different firearm stores. You can go in and take the test. Currently, and what they normally do with that, once you pass the test and get your blue card, the registry or the information that was used and gave you the blue card is then shredded. It's destroyed. There is no registry. So if somebody went to Department of Environmental Management and say, show me all the people that have applied for and passed a blue card, it doesn't exist. There is no database. They want to change that and make a database so that all the police departments could know who has applied for and who has received a license, the blue card, to purchase a firearm. Concern I have is that is a registry. It's a backdoor registry. Now, as you're aware, the Attorney General in the state of Rhode Island was sued years ago by the Providence Journal. The case is the Providence Journal versus the state of Rhode Island Attorney General's office, and they wanted to know all the information, name, address, contact information of everyone in Rhode Island that had a concealed carry weapons permit. That went to the Rhode Island Supreme Court, and the Rhode Island Supreme Court said to the Providence Journal, no, you may not have that information. It's considered confidential. This might be an end round around that because now that doesn't apply to an administrative agency, only to the Attorney General's office.
But this proposal would, instead of a police agency or the Attorney General, would go to DEM, is that right?
DEM would have to maintain a database of all the individuals that have applied for and passed the handgun safety test. So it'll basically be a record, excuse me, of all individuals who have applied for and passed the test. Name, phone number, everything.
Okay, we want to be clear that this blue card you're referring to then, the individual takes a test, passes the test, which is, who grades the test?
DEM.
Okay, so DEM says, yes, this person has indicated that he or she has a familiarity with firearms, I guess.
Has passed the safety course.
And they then issue a card saying that this is the case.
Correct.
The person keeps the card, but that's really the only record. DEM just does not, destroys the test itself, I guess.
Correct.
Okay, so that there is no central registry of people, but mere possession of a blue card doesn't mean a person buys the gun. They could just
Correct.
take it and then say, oh, it's too expensive, or...
How many people you know pass the test and don't buy a gun?
Oh, I don't know.
It's pretty much people that are applying for and are passing the test are going to present that when they purchase a firearm. It's required when you purchase a firearm.
Am I correct in understanding that a person who takes the hunter safety course is also then eligible to?
Under the current section of the law, and I gave you a copy of it, either you have to present the blue card or the hunter safety course card, and those both are the prerequisite to be able to purchase a firearm.
Does DEM keep a registry of the hunter safety people?
No.
No. So all that information is shredded and
Correct.
as opposed to concealed carry permits issued either by the Attorney General on a statewide basis or a municipal issuing authority, which is also good statewide. But those two people who issue, or agencies who issue, do have a record of at least CCW permits.
Correct.
Okay. Well, it seems to me that a buyer who lives in one town who goes to another town and buys a firearm, and it's important, I think, that background check in Rhode Island applies to all firearms, not just handguns, right? All firearms, you go through a background check in Rhode Island, rifles, shotguns, and handguns.
Yes, I believe so.
Okay.
Yes.
So the person files for that background check on a statewide basis. The dealer then notifies the police in the town in which the business is located.
Correct.
But what the Attorney General, as I understand what his position is that they did not or are not required to contact the police in the town where the buyer resides. So that's the issue in Westerly.
That's the
Westerly
issue.
Police Chief said, yes, we had numerous contacts with this individual, but we weren't notified by the Chief of Police in, I guess it was Richmond, where the gun shop was located.
Okay.
Okay, so if the Attorney General wants a seller to notify the buyer's police chief in the town where the buyer lives, how is that supposed to be communicated? Does a dealer in Warwick, for example, have to drive to Westerly and bring the background check to the police in Westerly, if that's what?
Simple clarification of the law. If the gun shop owner is faxing over the paperwork to the local police chief, it's very simple for that paperwork to then be faxed over to the chief of police in the town where it's located the same day. And that's the clarification that we put in the law. The police chief is then, in whatever city and town the business is located, is to fax over a copy or send a copy to the local police chief of where the buyer is located. It's very simple clarification in the law. It's a little ambiguous right now, but it's a simple clarification and it wouldn't be a problem.
So at the present time, it doesn't say that the information can be faxed.
Correct.
Okay. There was a radio show over the Christmas holidays that was hosted by former State Police Colonel Stephen O'Donnell that I don't know whether you were able to listen to it, but his guests were Colonel Manny and 3 serving chiefs of police. Mm-hmm. And they were talking about, at one point, about a software package or computer system they kept referring to as Fusion, which they said they've received government grants and it's been in development, and that now local police chiefs could communicate and access the information at another chief. Are you aware of this at all? Because I understand that one of the things that AG is talking about is we need to have this ability to communicate.
They do it now. One town does talk to another town, and one city does talk to another city on some level. If they're going to have something developed like an intranet where they can all use it, that's probably something what they're going to try to develop.
Okay. But it probably doesn't exist in the form that I'm describing at the present time.
Correct.
Okay. Let's change gears a little bit. We have probably about 10 minutes left. In an interview last December, Governor Raimondo said that one of her priorities, again, this legislative session, is a ban on military-style weapons. And she said she did not understand why anyone would oppose such a measure. How does the Second Amendment Coalition respond to the governor?
We oppose, absolutely 100% oppose her ban on assault, what they consider to be assault rifles. They're not assault rifles. They are just regular rifles, and any type of semi-automatic handguns, and a magazine ban. We absolutely oppose that.
Why? Well, isn't that a common sense solution to this problem that she says that we have of gun violence?
Define common sense. It's not common sense to me. It's not common sense to anyone that actually owns a firearm who sees the utility of having a firearm that would be the best home defense weapon, that has absolutely, be very modular. You can use it for hunting. You can use it for target practice. It's not common sense to any person that has any experience at all with a firearm.
These military-style weapons are rifles are visibly you can see what they are, but isn't one of the problems how do you define it in the law?
Correct.
So we had Colonel Manny on this program last year talking about, he was the co-chair, as you might recall, of the governor's working group on gun safety. And we actually had a model here of an AR-15, and I went through the sections of the rifle that are supposedly how you define a military-style weapon. And I said to him, which of these makes this more lethal than any other rifle? And he pointed at the magazine and he said that. So Attorney General Noronha, in a press release earlier this month, said that he plans to press for a ban on what are called high-capacity magazines, those holding more than 10 bullets. And what is your response to that proposal?
When the police department, individual police officers come forward and say they're going to reduce what they carry because they figure it's safer for them to carry 10 rounds instead of a normal capacity, then we'll have a discussion. The reason why police officers carry as much ammunition as possible is because they may be facing multiple threats. So they would have to have as much ammunition as possible. My life is just as valuable as yours, and in the event that we were carrying a firearm for protection, what would you say after you went through your 10-round magazine and you were empty and the threats were still coming at you? Would you say, oh, I'm glad that I'm a law-abiding citizen and I was restricted to 10 rounds? It doesn't make sense at all. If you're carrying for personal protection, you should be able to carry whatever the firearm came through factory with, 13 rounds, 15 rounds, or 30 rounds.
So the magazine issue, in your view, is really a reflection of the way that you buy a handgun, for example, with whatever magazine it comes with should be legal.
Yes.
What about these, the so-called drum magazines that are available? Should they be legal? Some hold 100 rounds.
Yes, why not?
Well, I don't know. Why not? Why should they be legal? I mean,
because
who needs to have a 100-round magazine in a gun?
It's an arbitrary number. If you're going to start putting a number on it, 50, 100, 30, 25, you have to have some basis for limiting my ability to protect myself.
Do you know where this, I'm always curious, where did this idea that 10 is the magic number, where did that come from? Do you have any idea? How did, I mean, it seemed, I know there's different states have different rules. New York, I think, is 7. And Colorado is 15, but most of the people say, well, limit it to 10. Do you have any idea where that 10 number came from?
I have no idea where it came from.
Oh. Very interesting. Are there any proposals that your organization would like to see passed that would improve gun safety in the state of Rhode Island?
For gun safety, I would like to see a silencer or a suppressor bill to come in. We are one of the last 7 states that still have one. In the event that you have to utilize a firearm inside of your house, you're probably going to have some hearing damage on that, unless you could have a suppressor on there. They're also very good for hunting dogs. Older hunting dogs are going deaf because there is no hearing protection for them. So one of the things we'd like to see is that gets some traction up at the State House.
When you say, okay, some people would call them a silencer, but they're really not, they don't
silence
the gun.
anything.
So the correct term is suppressor, right?
Suppressor. All it does is reduce the sound of the firearm. Doesn't eliminate it, it just reduces it.
I think last year, and maybe a couple of years prior to that, the Attorney General's office usually comes forward with a bill that would make the Attorney General the sole issuing authority in the state for concealed carry permit. Mm-hmm. Your reaction to that?
Absolutely not.
Why not?
If you have an Attorney General that is pro-gun and is very favorable, then fine. People can exercise their Second Amendment rights. They'd be allowed to get concealed carry weapons permits. What happens if you get somebody in that says, I don't believe people should carry, and just makes it so incredibly hard or just doesn't issue? When you only have one avenue for that, then we have an issue. We have a problem.
What about the idea that we need a single database for those who have a concealed carry permit? Because I think the Attorney General now just keeps track of those that his office issues and not those that are issued by other municipalities or issuing authorities. Do we need to have a single database of concealed carry permit holders?
No.
The anti-gun lobby says we do because a police officer who approaches a car, for example, or goes to a house should know ahead of time that a person that they're may confront has a concealed carry permit. Is that argument at all valid?
Okay. Most of the people that are responsible gun owners that know this, most of them, if they are driving down the street and they are pulled over, they follow the proper procedure and they alert the officer when they come over or when they're getting asked to step out of a vehicle that they have a concealed carry permit on and have a weapon on them. So if it is for officer safety, if people are following the proper protocol, it's not a problem.
Okay. But right now, a local issuing authority is not required to notify the Attorney General's office that they're issuing. Is that right?
I don't believe so.
Okay. Do you have any idea, getting back to your lawsuit in this federal court, any idea that you have to wait for the Attorney General's response before a ruling will come down?
The procedure is you can't file any motions, you can't file anything until you've received a response to your complaint. And all they've done so far is ask for continuances.
Okay, so at the point at which they respond to your complaint, what is your next step at that point?
Probably preliminary injunction.
Okay. Ladies and gentlemen, I want to thank Mr. Frank Soccoccio for appearing on the program. And on behalf of State of the State Communications, I want to wish everyone a very happy new election year in 2020. And let us all hope that the political discourse, discussion, and debate will be civil and honorable. Thank you for watching State of the State.